is Alena Shautsova. I'm New York immigration attorney. Today we're going to have a live, and this live is dedicated to new Asylum Ban 2024. Biden administration recently announced the final rule with regard to this particular ban, and I'm going to go over the main points. It's extremely important to know about this ban. It's extremely important to understand what's happening. This ban is going to be applied or is already in effect for all of those who meet certain qualifications and will be applied for those who are in court proceedings or before asylum interviewing officers, asylum office in affirmative asylum proceedings. And it's quite disturbing because it's going to cut off a lot of people from a possibility to ask for asylum in the United States. So let's dive into it and see what's happening. Because again, it's very, very important. Don't forget to like, share the stream. Please send your hearts. Send your hearts. Let me know where you're watching from, of course, as always, so that we're going to meet each other. I'm always interested in finding out where my subscribers, followers, or just people who watch me are from. And of course, like, share this video so more people will join, because this is a very important update, and the way the rules are written, they're very confusing. That's why I'm having this live, to give you some insights as to what's happening and to help you guys out to understand what's going on in asylum law, asylum changes in the United States, how it may affect some of your guys' cases, because this particular ban, of course, is going to have a drastic effect on some people's cases. You do know that if you don't qualify for asylum, basically asylum, it's a protection in the United States. But if you don't qualify for it, according to this new rule, which I'm going to explain in detail, you will be deported. You will simply be deported very fast. And unless you can meet certain exceptions, we're going to discuss. And even in regular court, not at the border, the judges, as I said, will be applying the same rules. So it's very important for you to know what's happening, right? Very important for you to know what's happening. All right, so let's dive into it. I see a good amount of people joined. Thank you very much, guys. Again, let me know where you're watching from. Hi, Ari from Boston. Hi. So let's talk about this. First of all, you need to know that the relevant time period we are discussing is from May 11th, 2023 to May 11th, 2025. If a person entered or attempted to enter the United States within these relevant dates, and they do not meet certain exceptions, and they do not have pre-authorization that we will discuss to come to the United States, or visa, or so-called lawful ways to come to the United States, they will be disqualified from asylum from May 11th, 2023 to May 11th, 2025. So from this point on, it will be extremely important for you guys to prove when exactly you entered the United States, as one day may make a huge, unbelievable difference in your case. The rule says that unless you're entering the United States on a visa, with a parole, or using CBP-1 app, you will be disqualified from asylum unless exceptions apply or you rebut the presumption that you are disqualified from asylum. So the lawful pathways to enter the United States from now on for the purposes of asking for asylum will be only three ways: CBP-1 app, visa, must be in your name, I assume, or parole. Parole can be one of those under one of those programs for Haiti, Ukraine, Afghanistan, Nicaragua, or Venezuela, for example, humanitarian parole of some sort. visa can be any visa, such as a tourist visa, for example, and CBP-1 entry that you received, and you have your appointment and you came on a date and time of your appointment. If you enter between the points of entry, let's say you have a CBP-1 appointment, but it's so far away, you're tired of waiting for it, you just want to squeeze yourself into the United States, and you go through what we call a hole in the wall. If you enter between the points of entry, or you just showed up at the point of entry, but you do not have a parole or a visa or an appointment, you present yourself at the point of entry, but you don't have the documents to enter the United States, you will be placed in expedited removal proceedings, and there you will be given an opportunity to either meet an exception or show that you can defeat the presumption. Who is not covered, or who is an exception rather to this rule? Unaccompanied minors, people below 18 years old, Mexican citizens, individual with parole, yes, those who do not have a CBP-1 appointment but can show due to technical reasons they could not receive it. There is such an exception in the rule, but it's extremely difficult to meet this exception in practice, because you either will have to show that the CBP-1 app does not operate in a language you understand, and no one could assist you to help you with an appointment, or the CBP-1 app had some difficulties, technical difficulties, that prevented you from making that appointment. We saw a lot of those difficulties at the beginning when the CBP-1 app was just installed, and now I think there are less and less opportunities to argue this point. You also will be given an opportunity to ask for asylum in the United States. If you already asked for asylum in any country en route to the United States and you were denied, but on merits, your own non-desire to proceed or to continue with asylum proceedings in a different country is not going to excuse you from this ban. Rebuttable presumption. If you can show that there are exceptional circumstances why you're not entering the country of the United States legally, or if there is a medical emergency, or there are imminent threats, serious threats to your life and health, or you're a victim of human trafficking, severe trafficking, then you may have a chance of asking for asylum in the United States, even if you enter between the points of entry. Special considerations are going to be given to families where one person out of the family that traveling together qualifies for an exception or meets the rebuttable presumption, could overcome the presumption, then the whole family will be released and placed in regular removal proceedings. It's still not going to be free as these people to go. I get a lot of comments online that, oh, these people just come in and they're free. No, they're not free. They will be placed in removal proceedings, but instead of expedited removal proceedings, those will be regular proceedings. The whole process at the border is going to happen as a two-part interview. One part will be screening a person for potential asylum ban, and then there will be credible fear or reasonable fear. If exceptions are met, or the rebut or the person could rebut the presumption that they are not they cannot apply for asylum, then they will move on to the next step, credible fear interview or reasonable fear interview. If they are denied, if the result of the interview is negative, they will have to ask affirmatively, meaning they will have to make an action. It's not going to be automatically, that an immigration judge reviews the determination. If the immigration judge confirms a  disqualification from asylum, there is no appeal. There is also no opportunity to request that asylum office reconsiders their determination, but asylum office may reconsider determination on their own. The rules do not say when it's going to happen. So as you see, the process will be extremely streamlined. It's going to be very important to prepare for your arrival at the border very, very well. And even if you squeeze yourself in and were not caught at the border, all these questions are going to be asked from you. You will be asked all these questions when the time comes for your either affirmative asylum interview or for your immigration court hearing with the immigration judge. This is what this ban is. It was installed by the Biden administration, went into effect on May 11, 2023. Final rule was published, I believe, it's relevant from May 11, 2023 to May 11, 2025. From what I understand, it can be extended. Quite significant change, because previously and for decades, there was no asylum ban for people who traveled through the points of entry into the United States. They could ask for asylum. And now it seems it will be extremely difficult to qualify for asylum if that's your mode of entry. You are forced into CBP-1 entry program, but currently it takes almost 300 days, guys, almost a year, that the person has to wait for the appointment through the CBP-1 entry. Otherwise, you must have a visa or parole. That's it. So as you can understand, this rule is going to cut off significant number of people from asylum resources. And again, asylum, if you win asylum, it opens up a pathway for your green card and eventually citizenship to bring your dependents to the United States. All this will be foreclosed for people who come to the United States and do not meet exceptions or meet the rebuttable presumptions, or rather cannot rebut the presumptions of disqualification from asylum between May 11th, 2023 throughout May 11th, 2025. So now you know the rule. If you're watching me in the United States and you arrived earlier, this ban should not apply to you. That's good news. But if you are a recent arrival within the next 10 days, so you're planning on entering the United States, you need to know that this is what's going to happen. It's going to be difficult to impossible to qualify for asylum in the United States. I think it's going to be even more rigid now than European Union rules. And now if you guys have some questions, I'll be very happy to answer them. Hi, Maximo. Hi, Peya. Hi, Seed. Hi, Kushal. All right, I have a defensive. Hi, Kushal. I have a question. I have a pending defensive asylum case. I had master hearing 2 years ago, but I haven't got any hearing dates in Dallas court. Can I ask court to open my case? But yeah, I have tons of videos about this. So what happens probably is that you are in a trial queue. You do not have individual court hearing date, and you just wait. You're waiting for the judge to have an opportunity to give you this date, which depends, of course, on the judge's calendar. Can you ask for the date to be advanced? Yes, you can. But chances are the judge is not going to give that. It's not going to consider that motion because the courts are extremely busy, especially if you're in Texas, as you just heard. I can imagine a lot of courts, judges, especially next to the border, will be busy handling the cases I spoke right now about, cases of recent arrivals, because those cases will have to be vetted. They will have to be sifted through the system very, very fast. So chances of receiving an expedited court date, in my view, are slim to none, all right? Unless you have a very convincing, very good reason, all right? Hi, Rizwan. Hi, Munir. Hi, YouTuber. Hello, Alena. My mom is a new green card holder and I'm over 21. if I overstayed and get deported, will a stay of removal help me to stay? Will the stay of removal will help me to stay? Stay of removal is a discretionary relief by ICE, which can be granted to anybody upon their discretion. So may it help you? Yes, of course it may. If you present your application well, if you have compelling circumstances why your mother needs your assistance in the United States, you may have a chance. Okay? You may have a chance. Hi, DP. Now I'm going to go to my TikTok followers. Let's see, you have a lot of questions there. Please, guys, ask me a question. Don't forget to send me hearts. Hi, CD. I entered by the border, but the problem is that I'm monitoring. Okay, you're being monitored with a smart link. Listen, if you entered somehow, it doesn't matter how, before May 11th, 2023, you're not subject to that ban, all right? You're an ISAP program, intensive supervision program. Not the worst thing if you have a bracelet or some kind of a link or you have to call. Alternative will be the detention that would put you into jail. I don't think you want that. Hi, Bechtas. What if marriage broke before permanent green card? It will be a tough case. Please consult with an attorney right away. You have to know that you cannot force your spouse to sponsor you guys. If your spouse does not want to proceed with I-130, there is nothing you can do about that. But if the spouse has been abusive towards you, then you may have a chance for VAWA. Abuse does not have to be physical. It may be financial abuse, severe financial abuse, emotional abuse. Usually those two go hand in hand, right? So consult with an attorney, see if you have any options, okay? Hi, Beppy. My removal proceedings dismissed without prejudice. Can I get lawful permanent residence with USCIS based on SITch I-360 approval? Yeah, you should be able to, as long as your priority date is current, right? Hi, user 781 and so on. I filed for my mother in May 2023. Nothing yet. I assume you are a US citizen. Permanent residents cannot file for their parents. And nothing yet. I mean, it's been a year. I would say it's a little bit long for a child-parent petition. But let me ask you this. Was it a concurrent filing with adjustment of status? Or did you file just I-130? For standalone I-130, it's a very long time. Parents' I-130s are usually approved within 6, 7, 8 months. But if it was adjustment of status package, when your mom at the same time filed for the green card, then I think soon you will have to have your decision, okay? All right. Hi, user 376. Good afternoon, attorney. I've been waiting almost a year now for a new green card. Can you answer me? Well, what is your question? Let me know what your question is, okay? You know, I'm not USCIS. I'm a private attorney, but if you have some question related to this situation, I'll be happy to answer it. Hi, Dreamwalker. Do you file N400 for citizenship? Yeah, sure. We assist people with N400 filings, especially those people who may have some concerns in their files related to criminal charges in the past, waivers in the past, those who file based on 3-year rule opposed to 5-year rule, those who may have issues with what's called unlawful acts. Yes, we help. All right. Can we explain for the US new rule, please? We just did. If you missed the beginning of the presentation, guys, it will be recorded on my YouTube and my Facebook, so you can always play it back and listen to it again. It's drastic changes to United States asylum system. A lot of people will be disqualified from asking for asylum. All right, both in affirmative or defensive proceedings. Extremely important to know the rules, guys. Big changes, big changes. All right, let me see. How high in IY? Can a citizen brother file I-130, I-45 for TPS sibling already in the United States? Not together. I-130 has a priority date that has to be current. So what happens is that usually those two cannot be filed together, right? First comes the I-130, 10 years has to pass about before it can be current, and only then, if the person, the beneficiary, is in lawful non-immigrant status in the United States, then they can file I-45 in the United States. If the beneficiary is overseas, they will have to go through something called consular processing. Well, guys, listen, thank you very much for joining and watching, sharing this video. This is a very important update. I wanted to give you this information so you are prepared. It's very strict. It's probably one of the most conservative rules, strictest rules that the Biden administration announced during the entire presidency. We're going to see how it's going to all unfold. I know that there is a possibility of litigation, meaning that the rule is going to be challenged in courts. But for now, you need to know that this rule may apply to you, apply very fast, especially if you're watching from overseas, you're watching from Mexico, waiting for your CBP1 appointment. If you had any doubts, if you should wait for it or not, now you have your answer, right? Only CBP1 appointment. No coming to the United States through any other way unless you are in imminent danger or you have a very heavy humanitarian, significant humanitarian reason. Don't cross the border, otherwise there will be no asylum. No asylum potentially means no any relief. You will be deported very, very fast. Okay, thank you very much for watching again. I will do another live this week on Friday. Hopefully everything will be fine and we're going to meet again. For now, don't forget to subscribe to my channel, follow me on Facebook, TikTok, and I hope to see you soon.